I'm back. Now we're going to pick up on page 145. For anyone that's looking to purchase product, this is my page, the home page, and this is the buy now button. If you click on that, you're able to purchase my product. And thank you for the increase. Now we're on page 145. And I'm going to start at the 307th Civil Affairs Group from St. Louis, Missouri, the 490th Civil Affairs Group from Albion, Texas, the 413th Company from Hammond, Louisiana, the 12th SS Group 2nd Battalion, headquarters unknown. They're ready to go into action. The problem is, as it appears, they were ready to take over the entire government of the United States as their mission set out. One man who attended the staging area talked to a civil affairs sergeant and asked him what his job was. The sergeant explained that the civilians of his country will really be surprised someday when the civil affairs groups begin to operate the government. Now, the Department of the Army still maintains that all this is not for the United States. Sorry. Excuse me. Yet this training continues here for us. The evidence is overwhelming. The plan exists for the imprisonment of millions of U.S. citizens. And even though all this information was presented to the federal magistrate, he still felt that no one was injured by such a plot. On the second day of September 1976, the magistrate recommended to the federal judge that the case be dismissed, and the sole basis for his reasoning to dismiss was that we have to be actually physically injured before we can maintain a lawsuit of this type. He did not feel that although this act of planning, preparation, and training was going on, that any U.S. citizen had been injured, even though the citizen may fear exercising his or her freedom for fear of being detained and imprisoned in a concentration camp at a later date. Ignoring the Constitution. The case of Tatum versus Lard, heard before the Supreme Court in 1974, is a case in point. It involved the Army intelligence collecting apparatus, which was developing a list of names of persons whom the Army felt were troublesome. The Supreme Court held that making a list of this type did not of and by itself present any injuries. The minority opinion in that case was that the injury in the case with a program such as this made people afraid to use their freedom of speech for fear of being sent to jail for it, but majority did not buy that argument. The difference between that case and this case, although we also have a computer program, is that we have something much further past that point. The concentration camp guard program and the civil affairs program for taking over of all functions of our government. In light of that, the federal judge said that this is not an injury. As a matter of fact, the U.S. attorney alleged that even if people were placed in concentration camps, if they were all being treated the same, they would still not have the right to go to federal court. On the 20th day of September, I filed a memorandum to notify the magistrate and the federal judge that I had discovered that the federal government had a program for a number of years to suspend our constitutional right of the writ of habeas corpus. This information substantiated the complaint. Habeas corpus is the name of that legal instrument utilized to bring someone before a judge when that person is being illegally imprisoned or detained, so that he or she may obtain his or her freedom. The Constitution states that the writ of habeas corpus shall never be suspended. I found the disturbing information in a report 94-755, 94th Congress, 2nd Session, Senate, April 26, 1976, entitled Intelligence Activities and the Rights of Americans, Book 2, on page 17B, entitled First Amendment Rights. The report states that more importantly, the government surveillance activities in the aggregate, whether expressly intended to do so, to deter the exercise of First Amendment rights by American citizens who become aware of the government's domestic intelligence program. Beginning on page 54, it is stated that beginning in 1946, 4 years before the Emergency Detention Act of 1950 was passed, the FBI advised the Attorney General that it had secretly compiled a secret index of potentially dangerous persons. The Justice Department then made tentative plans for emergency detention based on suspension of the privilege of the writ of habeas corpus. Department officials deliberately avoided going to Congress. When the Emergency Detention Act of 1950 was passed, it did not authorize the suspension of the writ of habeas corpus. But shortly after passage of that act, according to a Bureau document, Attorney General J.H. McGrath told the FBI to disregard it and to proceed with the program as previously outlined. A few sentences later, on page 55, it states, with the security index, use broader standards to determine potential dangerousness than those described in the statute, and unlike the act, Department plans provided for issuing a master search warrant and a master arrest warrant. This is the censor importance. It is the same thing that I am alleging in federal court, and yet the magistrate chose to ignore these facts also. We have government officials not only ignoring the will of Congress, but going the opposite of what the Constitution provides by planning illegally for the suspension of the writ of habeas corpus. In addition, as mentioned before, the master search warrant and the master arrest warrant are forms fed into the computer which print the names and addresses on them from the tapes previously prepared by the intelligence gathering program. As you are arrested, your home will be searched and anything found there may be confiscated. This program has existed since 1946 up to and including 1973, and without proper access to judicial discovery techniques, it can't be determined whether the same plan now exists under the same name or under another name right now. This memorandum was filed on September 28th. To make the court aware of the danger that our rights of freedom of speech and lawful assembly are in. But the court on September 30th, after this notification was received, dismissed the case. However, in keeping with the practice of federal courts in Houston of actively participating in the obstruction of justice, I was not notified of the dismissal until the 6th of October, which gave me 2 working days to submit any further motion in a 10-day period before the time starts running for the appeal. What I have just said regarding the federal courts in Houston is not only my opinion. The Houston Chronicle surprisingly published an extensive document severely criticizing the federal courts in Houston for making up their own rules as they go along with the proceedings, as well as commenting on the communist-like Supreme Court attitude of the judges and the court personnel. My experience here has been that the court has returned to me almost every document that I have filed. Then after a Gibb argument, they reaccept the document, stating that they just made a mistake. In reality, the power structure doesn't want these types of cases in any federal court. Summary of evidence. On the 8th of October, I had submitted a request for finding the facts in the filing, which had been established by the evidence presented. The 300th Military Police POW Command is located at Livonia, Michigan. 2. The Department of the Army has stated that said command exists per the Geneva Conventions of 1949, a treaty of the U.S. Article 4 thereof under the title relative to the treatment of prisoners of war and protection of civilian persons. 3. However, no such title exists in the Geneva Convention per se. 4. Nevertheless, there are separate titles, one of which is A. Multilateral Protection of War Victim Prisoners of War, B. Multilateral Protection of War Victims Civilian Persons. Nevertheless, Article 4 of both titles does not provide for the creation of any military programs for concentration camps. Whether Mr. Fernerin of the 300th Military Police POW Command has stated that the purpose of the command is for the detention of foreign prisoners of war and enemies of the United States. Further, Article 3 concerning civilian persons make the treaty applicable to conflicts occurring solely within the territory of the United States that are not of an international character, which is capable of including any type of conflict in its description, whether it be civil war or guerrilla activity or anything else. The text states, in case of armed conflict not of an international character occurring in the territory of one of the high contracting parties, each party to a conflict shall be bound to apply to the minimum of the following provisions. 8. Department of the Army Field Manual FM 41-10, Civil Affairs Operations of Civil Affairs Organization lists as one of its functions the assumption of full or partial executive, legislative, and judicial authority over a country or an area, and there is no specific exclusion of the United States as such a country or area. Said manual defines, number 9, said manual defines country along certain geographical population bases, county, state, regions, and national government. 10. Said organization has in fact conducted practice takeovers of local and state governments in the continental United States, including but not limited to the state of New Jersey. Said organization includes in its study outline on page J-24 a section on concentration camps and labor camps. 12. Said organization includes in its operation composite service operations and psychological operations organizations. 13. Said psychological operation working with the U.S. Public Health Service is prepared to operate any and or all mental health facilities in the United States as tools of repression against outspoken but nonviolent political conduct of the United States citizens in conjunction with all the above, which is to be used for the same purpose. 14. Further, the Department of Justice, in conjunction with this program, has had plans for the suspension of writ of habeas corpus since the year of 1946. Said plan depriving persons being detained under this total program any means for protection against tyrannical political repression. The plaintiff requested that the court make findings of fact and draw conclusions of the law consistent therewith as shown by the evidence on record before the court. The effect of this request is that the case must go back to the district judge for further consideration. I mentioned that it appeared that all this planning for concentration camps was to be directed against anyone, regardless of his political persuasion of ideology, who exercise freedom of speech against the established power structure of international bankers and multinational corporations, but with Proposition 13 type movements threatening to reduce taxes throughout our nation. I foresee an activation of emergency programs so that the parasites on the federal take will continue to receive their checks. Price of patriotism. In the same Senate document on intelligence activities on the rights of Americans referred to on pages 166 and 167, you will find that the federal government has targeted its intelligence activities against one group of Americans. On page 166, the first classification listed is rightist and anti-communist groups, and the first group on page 167 on army surveillance list, the John Birch Society as a number 1 and the Young Americans for Freedom as the number 2 target. Therefore, the groups of U.S. American citizens considered to be the biggest enemy of the United States by the federal government at this time is the conservative patriot and those who assert the Constitution and individual rights. Although this information has been available since April of this year, 1979. No one has mentioned this incredible discovery that the federal government considers the patriotic conservative as its greatest enemy. I have received all kinds of information regarding this case from all across the United States.